bullets. At page 1, at rule 197, at page...
How do you say 194 is only confined to consultancy?
Because just see bullets 306 with me, right-hand side. It will become clear. On the same page where you see 194, just see on the right-hand side 306. B, outsourcing of services, rule 197, non-consulting service. You just saw bullets 177A is consultancy service. Now bullets B at page 306 is non-consulting service. Means any subject matter of procurement which, as distinguished from consultancy services, involve physical, measurable deliverables, outcomes where performance standards can be clearly identified and consistently applied other than goods or works, except those incidental or consequential to the service. So that is what we are doing. And then for this, it has to be by tender, rule 200 and 201. All has to be by tender. The only exception is 204 at page 307. There is an exception, but it's a different exception. Both courts, unfortunately, go on the wrong provision, 194.
194 appears to be a kind of a non-obstante clause in respect of the entire chapter of this consulting services. Because if you
consulting service, yes. But we are not a consulting service. My lords are right.
That's why an exception is carved out.
The exception for
continuity.
I'm with my lords.
For the purpose of continuity of some project or work already going on.
Yes.
Then they say this entire procedure contemplated here, that can be dispensed with in a way, or it is exempted.
Yes. But even if you apply 194, there is no continuation by R2. Why? Because R2 bullets was contracted to provide outdoor mobile towers, which has nothing to do with the connectivity inside the metro, for which the equipment is completely different that we install. If we were subjected to public tender, how come they are not subjected to public tender? Even if you apply 194, there is no continuation. And that's the error concurrent, because they say it is a continuation. If I show you the provision, their contract says outdoor mass. And in fact, the nomination committee says we are modifying the contract to amend it to say in-building solution and outdoor mass, which gives the game away to show that it's not a natural continuation. Even 194 doesn't apply. But I am saying, 204 is the provision that they had to apply.
One clarification.
Yes, please.
Apart from the installations, as you rightly say, they are permitted to install the towers for their services, but they are providing an independent service of 5G connectivity, which your license does not relate to.
It does, So my license
to 4G.
Yes.
You are 2, 3, and 4G service.
In my license, there's a specific provision, fortunately, which says the moment there is an upgradation, then my license will also be upgraded. I want to show you that. Just kindly have annexure P3, which is my contract.
Yes.
At page 322,
Yes.
And we'll see clause 6.4. 6.4 at page 322 in my license. My lords are rightly putting to me, the first sentence. Page 322,
No, 322 not in the same.
Printed 322 of the main SLP. I'm so sorry, I'm so sorry. It's annexure P3. Relevant is page 322, 6.4 at the bottom of the page.
The
license fee of space as quoted by the bidder shall be for 2G, 3G, 4G only during the tenure of license agreement. Next sentence, please. In case of any technological upgradation beyond 4G, which is 5G, the license fee of space shall be reviewed on mutually agreed terms and conditions. Pursuant to this, on 1st of August 2023, which is the next annexure P4 at page 432, they upgraded.
No, sir. They do not upgrade it to 5G. They say that you may upgrade at your risk and cost.
That's right.
See the first line of 432,
yes.
If I am not wrong.
Right, I'm reading that, as per the above mentioned letter and meeting, the MRC is pleased to inform you Malaj, pursuant to 6.4, Malaj, it's not in controversy that I was given this rightly. Nobody is challenging my right because it stems from 6.4.
That is an enabling provision which allows you to upgrade yourself at your own risk.
And which they, Malaj, do by saying my contract was otherwise up to 2030 on 1/8/2023
Yeah.
for 5G
2042.
to 2042.
But interestingly, they do it as a firm extension for 4G services. With 5G services, they say that you may upgrade at your risk and cost, but they do not on mutually agreed terms.
Malaj, can I show you page 166 of the additional documents that may, Malaj, assist? Just kindly have the additional documents, page 166.
The extension is given, they right to proceed.
Malaj, they write to us, Malaj. They are the ones who come to us and ask us to do this pursuant to our contract at page 166. 20th April 2023, Malaj. Just kindly have that, Malaj. Malaj, just 20th April, Malaj, they write to us. This is to inform that the 5G technology has been launched by Honorable Prime Minister. Accordingly, S&T department-wide letter so-and-so had advised you to provide status of preparation of starting 5G services on metro station. Further in the matter, clause 2.2 F4 of license agreement is reproduced. The accepted license fee of space. This is the Mallad's invitation to mutually agree. Accepted license fee of space as per license agreement shall be for 2G, 3G, 4G only. And the license fee shall be reviewed on mutually agreed terms and conditions. In case of technological upgradation, exactly what I showed, my lords. In view of the above, it is requested to submit your action plan for upgradation of mobile network to 5G technology in section latest by 3422, which we did, pursuant to which 1 August, Mullad's now,
Pursuant to it, 1st August letter comes.
and Mullad's extension to 2040.
This letter, there is no firm commitment to you that yes, you can supply us with 5G services. It is at your risk and cost. That is what we are.
Well, there's no
clarification
Yes.
that the work order or the scope of work,
Yes.
will it include 5G
Yes.
in such conditions, or it would be treated to be an offer which is not accepted and subject to a subsequent decision making by the railway authorities.
Mullad's on the same day that they decide to award without.
Later, they give a contract because of the recommendation which is made by the negotiations committee.
Mullad's just
The
on 20.
negotiations committee, and then the High Court steps in and says that, okay, if that is so, we look into the public interest, the rate at which you were supplying,
Yes.
the negotiations committee had given a lower rate, the High Court upgrades the rate of the other private.
Mullad's actually, that's also an error by the High Court with respect, because they don't upgrade. What they do is,
What is the scope of interference by us one single judge?
I'll tell my lord. Mullad's, when should Mullad's a public authority eschew a public tender process? Surely, Mullad's, in the minutes of meeting, there must be application of mind as to why it should not be put to public tender.
They will definitely give a cause for the court to have the entire judicial review. The court must examine in that kind of case, that does it really serve any public cause or not. But that exercise has been undertaken by the High Court.
And my lords have held.
And division bench examined.
Unfortunately, Mullad's, that exercise was undertaken, but it was not noticed that at page 659 of my lord's paper book, the negotiation committee minutes of meeting do not even utter the word tender. They do not apply their mind to why it should not be put to tender. All the explanations come before the High Court as an afterthought. Under Mohinder Singh Gill, you can't improve. The second point I'm making, Mullad's, is that it destroys, Mullad's, my contract. Why? There has to be a level playing field. Why? My lords had put to me that they have increased their rate to the same as mine. But actually, that's not correct. Both High Courts have made this error. My lord, the rate is per square meter. My rate is 11,088 and the square meter is 20 square meter per station, which is mandated by terms of the tender in which I was awarded. I could not choose 20. They chose 20 and I have to pay for 20. They are being asked to pay without tender for 12 in each station. So it becomes a differential of 8 square meters. The total difference is my contract is 52 crores I have to pay to them. The differential and the public exchequer in their case loses 4.23 crores because of the differential of 8 square meters because there was no public tender. So Murad, no level playing field because Murad, the rates are actually different and both courts make that error. Neither
Time frame for which the allotment has been made to the private respondent?
they had to do it in 75 days from 13th February, which expired on 1st May. They failed to do it. After that, the High Court considers in the knowledge that they have failed to do it in 75 days. I have already installed the equipment and it's all done premeditated. How? I just want to give you 2 dates. 20th January 2025, they write to me saying, we asked you to put in 5G. You have not completed putting 5G. Without telling me that on the same date, behind my back, the nomination committee has already decided to award 5G to them. Which perhaps addresses my lord's right question to me, that had they already given you 5G? The cure notice says we gave you 5G. You have not fully completed. On the same day, they have already given to them. So it's premeditated. And on 13th of February, Millets, they give them the letter of acceptance without informing me. That is my third point. So Millets, no tender process, wrong provision 194, no level playing field, and Millets, premeditated award.
My lords, I appear for DMRC. My lords, as far as we are concerned, my lords have seen what the negotiation committee has said.
Now tell us only one thing.
Yes.
That if on one hand they are asking them to upgrade from 4G, 2, 3, 4 to 5G, and then without giving any breathing time, that is what some
Yes,
working
just on the
people are
question of
saying
breathing
that
time.
you are being awarded
See
the
page 166.
Yes.
Then your letter at 432, a prudent businessman is made to understand that yes, negotiations going on, you upgrade it at your risk, we will look into it.
Yes.
Now, you say they have failed in earlier cases. Now, notwithstanding that, you have extended the 4G contract to 2042,
My lord.
right?
My lord.
And so therefore, there is more or less a condonation of those penalties and failures.
Yes.
Then comes within 2 days, as a single source appointment, you give it to the
Can I just to get the dates right? In August of 2023, they are told you have a license. We are extending that for 12 years. But since every major mobile network has now shifted to 5G, you necessarily have to provide 5G services as well. Thereafter, there are a series of communications, all of which are on record, from August 2023 all the way till Jan 2025, where we are repeatedly telling them, please see, I'm getting complaints from commuters, I'm getting complaints from TRI, from the DOT, everybody, we have done a joint inspection, the joint inspection shows network is failing. Now this network is the lifeline because we are talking about an underground working. Ticketing doesn't work, payments don't work, effectively it comes to a standstill completely if network doesn't work. We are in an emergent situation. All of this is noted in January 2025 saying, for 2 years we have been telling you, please buck up. You are not bucking. Therefore, what are we doing? We are not cancelling his contract. He continues. We are bringing in, for the next 2 years, another operator who is anyway providing the signal. This is simply enhancing a signal which is provided by Indus, which is R2 before my lords today.
No, that is not the point that any interference in their working what has been allotted to. The point is that if there was a tender with respect to your work also,
My lord.
they would have competed for it.
Yes. No. Yes. The point that I'm making is this, my lord.
That is the only thing.
He is.
That why it is through private negotiation. Why can't if that A tender can be floated? Why not the B tender?
So here, my lords, as per his own license agreement, there is a clause, and I'll show it in a moment. If he fails to provide
Why
a
not
specific
the-
level,
Let us see what you are for the.
I'm for the tendering authority, my lords. At the end of the day, my
Not
concern is
tendering
this.
authority.
There should be network down there in the
You are
underground
metro.
area. My lord,
Metro.
I'm for DMRC. Metro.
Then you owe an explanation to our satisfaction that
My lord.
why did you opt for a private negotiation
My lord.
when in one case you could issue a tender? What prevented you to issue tender in the other case?
Yes. Can I just explain the background which has been noted by both the courts? From 2018 all the way till 2023, as my Lord Justice Bagchi noted, there are one series of complaints saying mobile network is failing. We thought this gets sorted out in 2023, saying please upgrade your infrastructure, become 5G compliant and provide 5G. Thereafter, for 1.5 years, we have a continuation of the same situation. As per his own license agreement, if he fails to achieve a particular rate, 99.95% or something, it's specified. If he fails to achieve that rate, we are entitled to bring in third parties to provide the service along with him, alongside him. That is precisely what has been done. Indus is already providing the service in the station. What they are told is, as a natural continuation, to use the language of 194, as a natural continuation of that service, please enhance your signal. Your original license itself requires you to provide an enhance. So please enhance it also in the underground section. Now, as for the last portion, what was the concern which was before the single judge is that today he says my license rate is about 11,000 rupees and it has been given at a lower rate. The single judge says this is not okay, please equalize it, which is what is done. So therefore, what the single judge and the DB have.
There's still a difference of 8 rupees or
12 square meters versus 20 square meters. He will pay 11,000 only on 12 square meters. I will pay 11,000 on 20 square meters. The difference is a loss of 4.23 crores to DMRC.
It is, my lord.
For lack of tender.
No, I'm sorry. That last part is definitely incorrect. Today, the position so far as DMRC is concerned is we are receiving a license fee from Mr. Sibal's client. We are also receiving a license from Indus, because they are in effect providing two different services, as my Lord Justice Bagchi has been noting from the beginning. 5G services today in these stations are being provided only by Indus.
Sir, we wouldn't have even batted an eyelid
My lord.
if you had gone into a tender like the way Mr. Sibal's client secured the contract for 4G. Then suddenly for 5G, what is the difference which requires a negotiation committee to say, no, it's an additional work
My lord.
for Mr. Sibal's license,
My lord.
and therefore it can be given to a
My lord.
third party through a single source.
Starting from the premise that, yes,
Really doesn't fall within the folds of the case.
my lord, if
Doesn't really.
just so that I am not embellishing anything, if my lords can just see what the negotiation committee has said in January of 2025.
4G, yeah.
What?
very well, enter into private negotiation. If you had floated a tender
My lord.
and there is no competitor,
Yes.
no bidding, or if at all suppose he says, he raised his hand, 4G I can provide, 5G I don't have.
My lord.
Then maybe you are right.
I would put it the other way. If my lords can just see Rule 194 for a minute, because at the end of the day, if I'm not going for a tender, I need to satisfy my lords that 194 applies.
You could also do it, suppose in the original tender to which, the first tender we are talking.
My lord.
If in response to the first tender, suppose you are asking 5G,
Yes.
and in the bidding itself, we say, look here, 5G is not I'm not in a position to provide, I can provide only 4G.
Yes.
You could still form a bona fide opinion
Yes.
that since you do not have any offer for 5G, therefore you will go for private negotiation.
What happens here is in 2023, I tell him, please provide 5G. He says yes. For 2 years thereafter, commuters are not facing signal at all. Forget 4G, 5G. He has till date not upgraded his infrastructure to provide for 5G. It is in this background that the committee sits down and says, we have this persistent failure by him in the past. His license is a non-exclusive license. His license itself permits us, where he is underperforming, to bring in people to fix that underperformance, which is what has been done.
When?
My lord?
Underperformance during which period?
From 2018 onwards, all the way up till 2025, the record, what my lords have in the additional documents is 180 pages
We
of
don't
us.
look into anything before 1/8/23.
Not required, my lord.
Because when
Please,
you give them the
Yes.
blessing for 12 more years,
Yes.
it's a condemnation of whatever.
after August 2023, I issue him a cure notice, I issue him a termination notice, all saying, despite us repeatedly
The
telling him, please
termination
fix it.
notice is after the allotment.
My cure notice, my lords, is my cure notice, my lords,
Yes,
is
so
in January.
your notice a show cause, you don't wait for the reply of the show cause, you go
I
and
can
allot it
understand, my
to
lords,
the
with
party.
respect. I can understand this if it's a termination case. What has been brought in, my lords, I can understand if I have terminated his contract. What has been done in this case, my lord?
And this is a largest which is to be given to the best performing party.
My lord.
Now, we understand you are dissatisfied with the response to the show cause notice, and pursuant to your negotiation, you give it as an additional work to a third party. There is no qualms. But what about a show cause? Is the show cause a lip service?
No, but with great respect, my lords, I can understand this a concern where we have terminated an existing contract. What has been brought in is where a service is non-existent, where
Still you are allotting.
what we have done, my lords, is where a service is non-existent, we have brought in an operator to provide that service so that at least the commuter trying to book a ticket is able to book that ticket. Because for the last 5 years, we have been trying to get him to provide that, and it has not happened. So far as price is concerned, what has happened is there is a market discovered price. That is the price at which it has been awarded to Mr. Sibal's client. What has been done at the level of the High Court is that we have matched that rate. So today, my lords, as far as I am concerned as DMRC, this is a service that the commuter cannot live without. This is a service that I also cannot live without because all my ticketing is done online. So unless there is network available in the underground section, the commerce of the DMRC does not move. Therefore, faced with a situation where he is either unwilling or unable to provide the service at all, I am required to bring in something. The negotiation committee undertakes precisely the analysis that 194 requires us to do. It requires us to arrive at a market determined price. So what we say is, we already have a price which is there under the contract with Crest. Please match that price. Initially, they express their inability, etc. But ultimately, where we land up is that the rate of 11,000 per square meter, which is what he has paid, is the same price that is being paid by Indus as well. And at the end of the day, as far as I am concerned, my lords, I am receiving my license fee. And more importantly, the commuter is able to at all access mobile services on that line, which was previously missing. My lords, I am told that in these last few months where they have been operating, two of the stations have already become 5G compliant. And by the end of this month, all 5 of these subject stations will become 5G compliant. This is something we have failed to achieve since August 2023, when Mr. Sibal's client has been working.
Tenderer
My lord,
took about 9 months to make 2 stations 5G compliant.
this tenderer, my lords, has been working for the past 6 months and achieved in those 6 months what they have failed to do since August of 2023. My lords know that since 2023, India has had 5G network. The DMRC, however, hasn't in these 5 stations until R2 came in and brought in the service. Today, my lords, I am not for one person or for the other. I am for ensuring that an essential service is available in this section. Today, thankfully, because of R2, it is available. And that really was what the negotiation committee set out to achieve in the first place. My lords will see the entirety of the focus of the committee is, today it is an essential service. It is not there. We need to make sure it is there. Every effort is done towards doing that. And why is again R2 the best person? Because they are already providing the service. They are providing it at the periphery of the station. What Mr. Sibal's client is doing is nothing but
This
picking up
respondent is also your old service provider.
my lord,
This second respondent.
second
for whom
respondent.
Private negotiation we have allotted. They are
Right.
also your old service provider.
They are mobile telephony providers who are servicing that station. So they have this mast outside, which is the mast that is actually generating this mobile signal. What their client was contracted to do but failed to do was provide an IBS. An IBS takes that signal, enhances the signal, and makes it available in the underground section. So actually speaking, if my lord sees the license agreement of Indus Towers, it is for provision and enhancement of the signal. Today, what are we asking them to do? Enhance the signal, provide it in the underground segment as well, which they have, my lords, as far as again, I am saying they have today done it. They have achieved it. Now, DMRC, my lords, is not looking here to award something to a complete third party unable of doing it. They are already on location. They are already providing this very service. They have simply been asked to extend it to the underground segment as well. So it is not as though we have cherry-picked somebody from out of nowhere, identified a favored party. None of that. They are already providing this very service. They are simply being asked to extend its width, its geographical width.
Malas, let's be clear on facts.
I'm so sorry.
Malas, the signal that comes inside the station does not come from the outside towers, which is the subject matter of R2's contract. Malas, for the signal inside, Malas, TSPs have to install an equipment inside, which gives the signal to my equipment, which I install. And that's how Malas commuters get the signal. Fact number 1. Malas, fact number 2, from 1st of August 2023, when my contract was extended by 12 years.
What it appears from their statement,
Yes.
that your performance has always been questionable in the past.
That's what I'm telling my lords.
Show cause notices, but unfortunately, because of the tender system, you are the L1 and therefore they have no choice.
Mullah, my friend is wrongly instructed, Mullah. My friend is wrongly instructed. Just have this fact, Mullah.
But appears
I say so without fear of contradiction. There is no letter to me after 1st August 2023 alleging any deficiency in service until Mullad's 20th January 2025 on the same day.
what about your past performance?
Mullad's past
After all,
performance,
ultimate central point is the consumers.
Mullad's today,
That they get the services.
today in all these stations, 2G, 3G, 4G is available. 5G is not available yet.
Use the 2G, 3G, 4G. Now
Today, most people use.
5G.
Today, most people use 2, 3G,
I am so
2,
sorry.
3, and 4G because 5G rollout is gradual by the various TSPs. Today, most people don't have 5G yet.
Most people have 4G and
Yes,
5G.
4G. So all that is there, Mullahs. Now, Mullahs, the first complaint against me for 5G is on 22nd May 25, which is Mullahs 3 months after awarding them the contract. Until 22nd May, no complaint against me for 5G. From 1st August 23 to 20th January 25, there is no complaint against me. Mullahs, remember, 1st August 23, they extend my contract by 12 years. There can't be any complaint, therefore, in respect of my service. They extend by 12 years to 2042. Then there is no letter to me. My learned friend said we have been complaining. Show one letter from the record. Not a single letter to me after 1st August 23 for the next Mullad's 1.5 years, right up to 20th January. And premeditated, why? Because how come it is that on the same day of 20th January, when I get a notice to cure deficiency, they are Mullad's deciding by nomination to give it to Mullad's Indus Mobile on the same day. And Mullad's no complaint about 5G for another 3 months until 22nd May 25.
So the first contract is which year you started?
My contract started 2019, Mullad's, up to 2030.
So what is code of 19 to 23?
Mullad's, my performance is evidenced by 1st August 23 when they extended by another 12 years. And commuters have 2G, 3G, 4G. Mullad's, this is technology that I'm providing. Because I got it fairly and squarely in a tender. Had they put up a tender, Mullad's, I would have competed in that tender. DMRC would have got more money. My friend doesn't answer how come it is.
That is the whole problem, that the money might have gone to DMRC. What about the consumers?
Mullad's,
What about the...
Mullad's, today there's no dispute. My
What
lords are right.
facilities, services they get?
Mullad's, today there's no dispute on two
The
things.
tender is not meant for their and
I'm with my lords.
for providing its
Mullad's,
service.
consumer is king. 2, 3G, 3G, 4G is provided. I have installed the equipment for 5G. Mullad's, I can only roll it out when the TSPs roll it out. That is a gradual process. It's being rolled out. Today, Mullad's, it's not available from them or from me. They were given 75 days in their contract of 13th February 25, which expired on 1st May. They did not do it in time. Today, they can't say that they are performing. But Mullad's, I am the pre-existing under a contract pursuant to a tender. Mullad's, if there's any deficiency in my service, Mullad's, they'll terminate my contract. But how is it, Mullad's, that you do it this way? Mullad's, kindly see how the level playing field is. Mullad's, I have to get at least 50% subscribers for 5G. If you give it to them at a lower rate, because they are only paying for 12 square meters and I'm paying for 20 square meters pursuant to my tender contract, then Mullad's, I will have to pay, I will get paid, Mullad's, all the... There's no level playing field because all the TSPs will sign up with them because they are paying a lower fee. I hope I'm clear. I will then be unable to comply with the 50% requirement in my contract.
Just two material facts which perhaps have gotten lost in that.
No. First is that through a private negotiation. Second, then in terms of the rate also, you are the beneficiary.
Two parts. And then I said, let's what?
Where the equal level playing field.
The will only consider this. I am a 2018 tender. He's a 2019 tender. My term is 9 years.
My 9 years expire on the 13th of November 2027.
This stopgap arrangement is for
Yes,
just 2 years.
Because, Malaj, otherwise, please see, he gets a tender in 2019, does not activate. 2023, he's told to activate 5G. From 2023 till today, and that's why, Malaj, please ask my learned friend whether he has 5G today. Very fairly says does not have 5G today. Despite a stay before the learned single judge, and in the last 8 months that I've managed to get some work done, I get 1 hour a day in the middle of the night when my people have to walk through the tunnel. I have activated 2 stations today on 5G. Theirs is a case, 5 letters on record which show they don't even have Airtel. Their case is Airtel is using obsolete equipment.
So just 3 points. This is a stopgap arrangement for a 2-year period. Their tender is
Valid till 2042. Number 2, it is non-exclusive. Number 3,
your lordships are told with regard to Rule
194.
The SLP starts on the premise that 194
4 is wrongly applied by the Delhi High Court. Ground E at page 550 is 194. Today, your lordships are told 194 does not apply, Rule 204 applies. Please ignore all of that. The short question, as your lordship rightly put to the solicitor, is, does DMRC have discretion? Has it been correctly exercised? A case where, as your lordships note, the consumers have not had a chance. They have not been able to meet from 2018 onwards letters on record which demonstrate that consumers are facing
difficulties. As the learned solicitor points out,
2023, they are told, please upgrade at your own risk, but it's not just at your own risk. You get a 12-year extension. But what Mr. Sibbal does not tell your lordships, more importantly, is he was the sole bidder for that tender in 2019. So sole bidder, 2030 contract last outer, without a tender
gets an extension till
42,
is unable to activate 5G till today. For some strange reason,
I am so incompetent that I managed to activate 2 stations today between then and now, and I will activate the rest by December 27th. Those are my instructions. So, Manoj, please consider the balance of convenience today, and that's why your lordships noted. Am I getting a 2042 contract? I am not. I am only servicing my, let's just have that last page. The last page of the negotiation committee, Manoj, and I am asked to meet the market rate. The market rate tendered was 2,500 rupees. I was told 5,500. The learned single judge, Malad, balances equities and says you will match the 20,000.
But despite that, Mr. Sibbal's argument is that you are still beneficiary.
Well, it's only on one aspect of the matter. Please consider. Jan Malad and Mr. Sibbal also makes a very important point. He says if they had tendered, I would do it. What he could not do since 2023, I asked myself, Malad, will he be able to do it today? And it's a non-exclusive tender. It's a stopgap
to ensure that 5G is made available.
Mr. Counsel, we understand that Mr. Sibbal's client has not done it.
Yes, please.
But as you say, your allotment is also non-exclusive.
Yes, please.
So Mr. Sibbal's client should have a fair competition on a level playing field.
Yes, please.
Now, if you are given the same license fee for a lesser area compared to Mr. Sibbal's client, where is the fair playing
The matter.
field?
Mr. Sibbal's client has an extension till 2042. I have to.
Irrelevant. That is irrelevant.
So therefore, Malad, the difference is
8 square meters per station, 5 locations for a period of 2 years. Mr. Sibbal's client gets 20 square meters. 12 square.
File your short affidavit only on the this rate contract.
We can do that.
We'll do that.
And Mullah, just because my lords were rightly concerned about the commuter, I have instructions as follows. All our stations, without exception today, are 5G compliant. Point number 1. Our one station, Mullahs, is also running 5G. Mullahs, we depend on the TSPs to provide the 5G, but we are 5G compliant in all our stations. Second, only the tunnels where the trains run remain to be upgraded. Indus R2 also does not have 5G in any single tunnel at all.
When have you upgraded it while during litigation? Yes. Because earlier your performance doesn't show that you had.
Mullahs, up to 1st August 2023, whatever was there, I have paid the penalties, Bullets, and they have, Bullets, after being satisfied, they've extended it.
Well,
The fallacy.
The answer to the hardship and look at the.
Bullets, today, my lords are right. I am also concerned.
Prevalence.
Every commuter has 2G, 3G, 4G. In all my stations, they have 5G available.
They can't even buy ticket, anything unless you provide these.
Mullahs, I'll tell my lords one aspect. Airtel is the Mullad's parent company of R2. So Airtel doesn't cooperate. This is the game that's being played. DMRC and Airtel are there, Mullad's, pitted against us today. But what is, Mullad's, the commuter is paramount. 2G, 3G, 4G is there. 5G, all my stations are compliant where I've installed IBS. But Mullad's, if TSPs are rolling out slowly, it will come slowly. In the tunnels, we are in the process. My friend is right. We get to work 1 hour a day. It takes time. But Mullad's, until 22nd May 2025, 3 months after awarding to him, no grievance raised on 5G. There's no answer to this from the other side. There's no grievance on 5G raised till 22nd May 2025. There's no answer. If you look at the minutes of the negotiation committee, they don't mention Rule 194 of the GFR at all. They don't mention the word tender. They don't apply their mind. All these explanations are coming as an afterthought to cover up the Mullard's award to them by stealth. And well, that's the issue here, Mullard. There must be guidelines for these public authorities not to have Mullard's sweetheart deals, avoiding Mullard's the requirement to have public tenders.
Can I just correct my learned friend on two things? So far as the Delhi circle is concerned, I'm making this statement with some responsibility. The two biggest operators, Reliance Jio and Vodafone plus Airtel, together 80 plus market share, 80% plus, have been pure 5G networks since 2023. There are possibly smaller areas, rural, semi-rural, where 2G is still operating, as my Lord the Chief Justice said. So far as Delhi is concerned, so far as these 5 stations are concerned, the 3 biggest networks in India are pure play 5G networks. So to say I can't provide 5G network and I'm not providing it in just this underground section means you are effectively not serving the purpose at all. And that purpose, as my lords have been saying repeatedly, is ensuring availability of network to commuters in this specified area. So far as default is concerned, the default is not something DMRC has come up with. There are commuter complaints. DOT has written a letter to us saying, why are you not providing network? It's on file. TRAI, which is the regulator, has written a letter to us. Again, it's part of the file before my lords, saying in 2025, saying, why are you persistently failing to provide 5G network? Commercial rollout for both Airtel and Reliance Jio was in 2023. For 1.5 years, the network that is available everywhere, including in the station, is not available in the segment that has been contracted to him. Until, my lords, R2 was brought in. So today I am not batting for anybody in particular. I am batting for the availability of the signal, which is finally there.
File your short affidavit that is explaining the
We'll do that.
to the allegation, but Mr. Sibbal has raised.
We'll do that.
Issue notice then once there was accept notice on behalf of member 1 and 2. But the brief affidavit with respect to the brief affidavits. Let responder 1 file a brief affidavit explaining the circumstances in which the tender could not be floated for allotment of the work providing 5G services, as well as the circumstances, as well as a brief reference to the circumstances which prompted to allocate the work through private negotiation.
And that the proposal, I think prescribed rate.
You should deposit the same license fee then. Can they deposit the same license fee? Okay. Let's keep the pressure on. Otherwise, keep it at the earliest. छोड़ यार छोड़ उसको
It is also approaching. It is also approaching 15 minutes.
It's just like
2 days, 4 days. We have to do the file within 4 days. Post the matter next Monday.
we are praying for stay. Otherwise, just don't, I want to make a proposal.
Mr. Agri, 2 courts have decided against you. There is a
Proposal. I am 5 station compliant. Give me a chance, see how it is, and report to your lordship.
let us see how they.
Don't say that he is better. I am saying I am better. I am compliant. 5 station compliant. Let them give me a chance. We will report.
There is in a fight on a private interest.
Yeah.
There is some element of public interest that is also emerged. We would like to first address that one. So let us see that how they respond.
Complaint equity. I mean, they say
We are keeping next Monday only.
Mullards, we struggle with permissions for the inside tunnels. My instructions are we can do, Mullards, the entire 5G rollout, including tunnels in 3 months. And I can put it on affidavit.
This very context we will also file on
Yes.
it. The petition is also
Yes.
permitted to place on the
Yes.
judicial act.
Can explain?
Yes.
It's done since 23.
Not my.
You should actually push on about
Should we keep it at a shorter date?
Monday,
A shorter date.
Monday, sir, next.
Go off by
Next
around.
Monday.
They can put it in a week's time, they know now everything is here, we are here.
They need to sell within
Be as short as
Absolutely.
possible.
4 days. Within 4 days, the petition will also file an additional
One
affidavit.
day.
Additional affidavit within 1 day. Post the matter next Monday.
Obligements.
Most people. Your lordships consider, I'm just calling upon them to explain what they've done since 23, because they've had time since August of 23.
Most of the statements that were
That's
made
right.
here are not in any pleading. They're not in the SLP.
The only request is file brief affidavit.
We'll do that.
We deliberately use the word brief.
We'll do
So that we are able to read it.
We'll do that.
Obligement.
Oblige.
Good, here.
Yeah, Manoj, may I just, with your permission, just tender an affidavit, which I just have. We need a little help here because this is a stock in trade in respect of a company which has suddenly been deprived of just doing any business. We'll just have a look. I'll just explain the problem. I've just handed in a affidavit. Manoj, we have 20. I'm sorry. Yeah.
We have understood a little bit.
I have given 21 flats.
Very harsh order.
Very harsh. And Manoj, the appeal is only on forensic audit. Only on forensic audit. So I request a stay, Manoj, of the impugned order as well as the earlier order of.
We will stay that part of the order. That will take care of your.
Yeah, they're correct. Saying for consent, your lordship will just see the order, that portion of the order.
You want us to stay?
There's paragraph.
The
Three.
consent part, probably if you stay that,
Yeah.
that will take care of your problem.
Yes, sold with consent.
That-
Yes, that's correct. That is correct.
Issue notice, liberty to serve the respondents to.
There was an
Get me the September order. Yes. Yes.
Meanwhile, direction contained in the impugned order, to the extent that the appellant shall be required to put the exact language consent. The appellant shall be required to give their consent or denial within three days of from the date of informing of the proposal. Meanwhile, I think there are 3 if we completely still.
Yes.
The requirement for consent may be stayed
But that undertaking will remain that you will not transfer to related persons.
to related parties. Yes, please keep that.
Meanwhile, para 3 of the impugned order, dated 18th November 2025.
Any
To
stock
the
is
extent of,
If any stock is sold, it shall be with the consent of the.
to the extent of requiring the appellant to obtain consent for disposal of the stock, for the sale of the stock shall remain stayed. However, the appellant shall abide by
the
by
orders.
the undertaking to the effect that it will not sell its stocks to
To related parties.
to the related
To
party.
related parties.
Also
And your lordship may clarify that sales to third parties may continue and I'll maintain account.
Subject to further compliance by the appellant.
of the order of the NCL.
The order dated June 14, 2024. That's only
Yes,
procedural
yes,
format.
Yeah.
June 14, 2024, passed by the NCLT Jaipur bench. in CP number 14/241-242/JPR 2024. That is only requiring you to give
Inventory, etc., and books of accounts. being-
Yes, yes, that we have.
That obligation are statutory
Yeah,
obligation
Your
only.
lordship is correct. Grateful. So that affidavit would be on records.
Yes,
We have just given it.
take that.
I'm grateful.
I will take a note. Item 26.
Please. May it please, man. Pursuant to my lord's last order, my lords, I placed on record the caste certificate, my lord.
Where are the documents?
Lords, I placed it on record, my lord. Pursuant to my.
You are giving today?
No, lords, I placed it on record on 27th November.
I see.
My lords had
Oh,
granted me 1 week.
306 for dinner, 306 455.
Please, my lords. At page 4, my lords. That's a photocopy of the original. I have the original also, my lords, the caste certificate.
This P4 was, this page 4 was issued on 14th October 2022.
Please, my lords.
What was the date of nomination?
Nomination, lords, the date of nomination was, my lord may have. The dates of filing nomination papers were 21/10/2022 to 28/10/2022.
So before nomination you had opened.
Before.
Is it correct?
Lordship, this is correct, as per caste certificate, इसको certificate is Ghasiara, Bengal, page 100.
No, point is that when before she contested the election,
Lordship,
the competent authority in the state of Haryana had issued a certificate in favor.
issue certificate there after inquiry, he has filed second, page 73, Lordship. Bihar.
What is found that is
After inquiry, state of Bihar, 17th April.
5 and 6 also. Sarwan Das, her father,
Different,
is also certified to be belonging to scheduled caste community.
Yes, Sarwan Das, Shobhan Das.
different. Kindly see finding Lordship, page 100 Lordship. Petitioner was married with the Amirak Singh, who belongs to caste.
Amrik Singh belong to which community?
General.
Jat.
General.
General category.
Jat.
Husband belongs to general category.
General category caste,
Then?
Jat Lordship. Thereafter, school certificate, BC,
Karnal district, Jat.
Ghosiara, Ghosi, Bengali BC Lordship.
Please, ma'am.
Yourself to be a downtrodden or the marginalized community. Fortunately, Jats in Karnal district or maybe in other parts of the state, they are well placed. And of course, because of their hard work, they are very committed agriculturists mostly.
Lords, her father is a laborer, lords. He's not, they belong to marginalized community only, lords. She's only ninth
Marginalized
pass.
community you may not
He's
be,
not,
but
lords,
your problem is that, you see, problem is three. There are three problems. One, the certificate which you obtained
very.
was eventually found to be wrongly issued. It was cancelled. It was cancelled.
Lords, with respect, it's not cancelled. I specifically mentioned in my SLP, lords. Till date, it is not cancelled, lords. That's what my grievance, I've specifically taken that ground. It's not cancelled till date.
Secondly,
Well, in fact, if I
secondly,
got.
your father is also now becoming doubtful whether Shobha Das or Sarwan Das.
My lords,
Different person.
the respondent authorities, they conducted an inquiry through the authorities in Bihar. That inquiry report of the Bihar authorities addressed to them is at page 87.
Sir,
That's very important.
there is no dispute. Sarwan Das is a scheduled caste.
Please,
The person Sarwan Das and
Sobhan Das.
and your father Sohan Das, you claim to be one and same person.
one and the same.
The pictures are different.
Different.
No, my lords, if my lord see page
The
87.
pictures of one and same person
No,
look
the
different.
authorities in Bihar specifically say this, they are one and the same. I don't
Finding
say,
of
my lord.
fact. This is a finding of fact in the order.
Lords, that's factually incorrect, my lords. With due respect, my lords, I have
Page
88. I'll show that, my lords. Page 88, my lords. My lords, I have.
Having documents we received the map.
Lords, kindly have page 88, my lords. Kindly, what is falling from my lords, my lords, that is answered at page 88.
Better you do one thing, you
Please.
file a civil suit for declaration, where you can obtain a declaration that you belong to this category, and
No,
next time then you can
I
contest
may
the
do
election.
that, it's a limited term. Before also I approached my lords, 1 year I was deprived.
2022 to now 25 end, you have substantially enjoyed the.
Lords, in the 1.5 I wasn't there, my lords. I was reinstated pursuant to my lord's
So
order.
you remember, we reinstated you,
Please, my lords.
and
Grateful.
thereafter you have worked well.
Lords, there's not even an election petition filed. It's by an executive order. It will be misused, my lords. It'll create havoc future also. What they're doing is by executive order they're doing, my lords. Page 88, my lords, may have, my lords. I'll try and persuade my lords on that.
Parties,
Lords, kindly see.
a record including the additional documents placed in the court by the petitioner. We see no ground to interfere with the influence judgment of the High Court. The petitioner, however, shall be at liberty to avail her remedy before the civil court in accordance with law. In accordance with law.
Lords, kindly consider the inquiry report of the authorities say he's the one and say, I don't say. my lord.
Remedy, if any, then say in accordance with law.
My lords. Not the mediation has begun, my lords.
Honorable Justice
Justice.
Nageshwar Rao has already met the parties. Now, my lord, it is posted for 11th of December. My lord, there are some parlances which are going on, some proposals are there. I only request.
We have
everyone
already
can-
submitted, my lords, 12 labels, and I suggest your lordships may have it in February so that my lords he has sufficient time.
That's fine, my lord. That's all.
Lance, counsel for the parties state that that mediation is still going on. And they are hopeful of resolving the issue amicably. Post the matter, as requested, post the matter on responsive date.
I'm grateful to you, Lord. Well, item 28 will also be. Yeah.
Both matters.
Both
Yes.
matters. I'm grateful to you, Lord.
Grateful.
Deeply obliged.
Yeah, वो याद ही क्या कर रहा हूँ। Oh,
Blood,
what happened, Mr. Dutt?
blood, they gave a statement in the morning that they'll make all the arrangements. In the evening, they requested the arbitral tribunal for a special hearing by video conferencing and gave a statement that they're not able to make the arrangements, so the date should be vacated. It's most unfortunate, blood, after making statements here that they'll make all the arrangements, then they, blood,
No, who is appealing for this?
solicitor.
Have you informed, can you?
No, I can pass on the order of the tribunal, blood, in the evening.
Tribunal's order is fine, but we would like to record their statement. We are not, see, we are not examining judicial review of the orders passed by tribunal on every day.
No, blood, tribunal in any case said that as far as whether they have reached any assurance, that's within the remit of the Honorable Supreme Court.
Madam,
And
what are your instructions?
My lords, I am being led by SG. My lords may pass it
We
over.
are told that you could not make the arrangements.
My lords,
You
we
couldn't make them go
proposed the
there.
options. They rejected it, my lords. But I may be given a pass over, my lords. My lords, I'll just seek a pass over. I'll place that order also on record, my lords. The tribunal's order.
Saying what?
My lords, they have deferred it to July, considering.
because they said that we can't make the arrangements.
Oh, they have deferred
My
to
lords,
They have
the.
deferred it
my lords,
because-
this is out. My
Then
lords,
this matter is in structure, then we keep the question of law open. Say we are informed that the arbitral tribunal, International Arbitral Tribunal has deferred the hearing in July to July 2026. That being so, comma, for the present, comma, the subject controversy has become infectious.
Plus, would your lordships keep the question of, because my lord, kindly see, in this matter, my lord,
However, the question of law is kept open. How the question of law is kept open. We hope and trust that the parties will fully cooperate with the arbitration tribunal to ensure that the that the hearing take place as per the revised schedule.
No, my lord, it's gone to July, my lord. If the lordships can put a word that if some, my lord, if their calendars.
If we do something, then again you will say.
No, my lord, because, my lord, since your lordships had observed, we had the lordships' wishes, we tried to resolve. They made a statement, my lord, everything will be arranged, and then they said.
My lord, we had given them options, my lord. It is not that we have not cooperated or not.
No, the cooperation the parties may, the parties will, however shall be at liberty to jointly request the arbitration tribunal to provide an early schedule of hearing. Early schedule of hearing, such a request may be considered sympathetically by the arbitral tribunal.
Your lordship take this on record, my lord.
The petition is disposed of as infructuous. However, the question applies to appropriate.
My lord, would your lordship take this order on record, my lord, because it says that it is deferred, which your lordship has recorded.
All right. And have placed on the ground a copy of the order passed by the arbitral tribunal, indicating that the proceedings have been referred to July 2026.
Yes.
My lord.
Item 15.
My lord,
There is some
I
IE
would
for
respond, my
additional-
lord. This issue is covered by your lordship judgment in Tamil Nadu Housing Board pertaining to Coimbatore, my lord, identical facts. That is a judgment dated 25/12/2024, where your lordships have held, my lord. I can pass on the judgment.
Lord,
I'm
for the appellant, Lord. I'm for the petitioner.
Yes, my lord, let me say, my lord, then I will make my submission.
Lord, right to fair compensation act has been sought for. Your lordships are aware of the twin conditions, not either possession or compensation. It is an admitted fact, Lord, that possession has been taken. Last year, lordships passed a direction to ask about the compensation which has been paid. Lord, we have filed an annexure. Lord, lordships may kindly see the annexures. In IA number 11852, Lord, of 2024.
The problem is that you are a subsequent purchaser.
No, my lord, it is not correct, my lord. I am not a subsequent purchaser, my lord. I am in the award itself, my lord. I purchased during the pendency. My award itself is in my favor, my lord.
After section 4, before section.
Lord, during the pendency of the award, my lord, I was participating in the award. It's not a subsequent purchase.
Right, it's my lord.
And let this question be. High Court has unfortunately not dealt with this issue.
No,
we can remand the case to the High Court with a
request that I want to have a suggest a method, my lord, because this is small cent, 29 cents, my lord. I filed additional documents, so all the neighboring plots have been released by them. The NOC has been issued by the housing board, and even the adjacent land, part of that also been released.
Right. On that ground also, we will leave it.
Your lordship, this judgment is very clear, my lord. I can just this is housing board, Coimbatore.
That is Coimbatore, my lords, my lords.
That is Coimbatore. That's why I'm
It's in Chennai, prime area, my lords. It's a
prime
different
area,
matter.
yes, my lord, 29 cents, my lord, adjacent. I can show those photographs. Lordship may kindly have paragraph 21. My lord, that too, my lord, the two things, my lord. The payment was not made at all. The award was of 87. Then the further review was, enhancement was in 2010. They deposited in 2017, my lord. But the original
point is not this. Point is the subsequent purchaser. That is.
I'm not a subsequent purchaser. I can show from the award itself, my lord. I was participating in the award. That I can, if your lordship wants to satisfy. Your lordship, I can say. Because the High Court has not gone on this subsequent. High Court has only said at that time, although my statement was they have neither taken possession nor deposited the compensation. Single judge says yes. Division.
But there is a finding of fact there that may you may not be.
No, my lord.
It all depends upon case to case.
Single judge clearly record, DB record, my lord, the payment has not been. Your lordship gave a direction in 23 to substantiate. Then they filed something they filed in 2017. Possession has not been taken in accordance with law, my lord, which your lordships have held. This is the procedure. Nothing on record to say when possession has been taken. So, my lord, more so, adjacent lands have been released, my lord. I can show those, my lord.
It was admitted on record that the land acquisition collector never took the possession.
Yes, no, no, here also, my lord, it is there saying there is nothing on record to show possession has been taken. The amount which was paid in 2017, my lord, they say that is also 87 is the award, now 2017, and the enhancement was done in 2010.
All right, I think we direct this issue also. I could examine also. It's a leave granted. Her land counsel for the appellants as well as land senior counsel for the respondents. The issue that calls for consideration is whether the subject acquisition, which was initiated way back on 17 July 1978, is liable to be declared to have lapsed under section 24(2) of the right to pay compensation on sales 2013. So the High Court has wide improved judgment held that neither compensation was paid nor possession of the land was taken, and hence both statutory conditions having been satisfied, the acquisition has lapsed. Next paragraph. During the course of hearing, 3 questions arise for consideration. Namely, 1I, the appellant's case is that the respondents are subsequent purchasers and therefore they cannot invoke seek declaration in section 24(2) of the 2013 Act. On the other hand, the respondents vehemently contest this issue and they deny their status as the subsequent purchaser. So this aspect has not been gone into by the High Court in the interim judgment. Next paragraph. Second issue that arises for consideration is whether the land acquisition collector had taken possession of the land, with or without depositing the compensation amount. So there seems to be, it seems that a better clarity is required to determine this question of fact. So that is also not discernible from the contents of the interim judgment. Next paragraph. Third thing, the third issue will be that if the authorities, if the state failed to take physical possession of the land or the compensation was not paid, and if the subject land is still required for completion stroke execution of a public project, what should be the recourse that should be allowed to be adopted by the appellants. So this question has been effectively answered by this court in somewhat similar circumstances in the case of Tamil Nadu Housing Board versus Kotha and others also. So in the next circumstances noticed above, it seems to us that the above 3 questions need to be factually determined by the High Court. Consequently, without expressing any opinion on merits, we allow this appeal in part, set aside the interim judgment dated 18/8/2017 of the High Court and remit the case to the High Court for redetermination of the questions herein above or any such question that may arise for consideration during the course of hearing. The parties will be at liberty to raise their respective contention and also file additional documents if so required for the consideration of the High Court. Next paragraph. We request the High Court to having regard, we request the High Court to accord prioritized hearing with an endeavor to decide the matter within a period of 4 months. Next paragraph. The parties are directed to maintain status quo, recreation of third-party rights, construction, or creating any encumbrance on the subject property till the matter is decided by the High Court.
One factual position, my lord, award. At the time of passing the award, my name figures, my lord, 82, my land, extent, everything is there. Subsequent purchases, the issue raised only in the division.
That's why we are not saying so.
So it's not an issue at all, my lord, subsequent purchases.
No, here it is specifically raised before us.
No, my lord, in this case, of course, in the division, my lord, against the division bench, they said by the time, my lord, indoor.
Question will be what does mean by subsequent purchase?
Yes.
Suppose if a notification for is issued.
Yes.
And he purchased thereafter.
Yes.
Two questions, and we have all answered it. The High Court will also examine.
Judgment, my lord.
In fact, even the sale deed can't be executed. But if you have purchased it, are you not a subsequent purchaser? Admittedly, you will be.
No, my lord, but my only case is I participated before.
Participated in highway hearing.
My lord, notice was issued to me. My lord, notice was issued to me. I participated, and my lord, they have released the.
That is your point that you participated.
Yes. No, I'm not a subsequent purchaser in that sense.
But the award says he's a subsequent purchaser.
No, my award doesn't say, my lord.
So let's see, we have kept it open.
Obliged, lords.
Item 16.
My lord, item 16 may kindly pass over the matter. My lord, we are led by seniors.
Lordships, I have to say something.
I am for the claimant, my lord, in the first matter, 16 and 16.2, my lord. Respondent.
May I say, Lordships, this is an MD matter and service is not complete. My application for Lordship substitution, it is pending since long. Lordships may decide that and Lordships may hear it on any day convenient to me, Lord.
But today, only some affidavit has been filed by you.
Yes.
Regarding compliance of those deposits, etc.
Of the order dated, Milos order dated 4/7/2024, Lordships, we complied with Lordships. We made an application for substitution with condonation of delay application. I was down with Empima.
These demand drafts are lying where?
Please, my lord.
The amount has been deposited with the registry.
That has been permitted to us, my lord. 50% amount we have got, my lord. My 15th March 2022 orders, my lord. Passed by this honorable court.
Lordships, what I respectfully submit, Lordships, I also want that this matter should, Lordships, may be decided.
Once the case is to be decided.
Matter was
The
sent
substitution
with mediator
application
also, my lord.
Lordships, the
Mediation.
substitution application may be allowed.
Compensation amount has been deposited in the accounts of the
Lordships, what will happen, Lordships?
donors, post the matter for hearing on a non-Muslim. That will be allowed.
Lordships, what I respectfully submit, Lordships, by substitution application may be allowed, otherwise.
That we are allowing.
Yes.
We are allowing that.
Highly allowed.
It's a fixed date, my lord. Maybe given, we have mentioned many times also, my lord. 2004 acquisition, my lord. Some date.
Obliged, Lordships.
Next item 17.
I appear for the respondents, my lord.
Whereas in item 17, I have just entered appearance, my lords, and there are two connected SLPs. May I get a short accommodation, my lords? I just need to go through.
Give us the number of those to list all the matters.
My lord, subject to the convenience, my lord, to the business of the court, my lord, may it be fixed on a Wednesday or a Thursday, my lord. We are suffering for an interim order, my lord, since long.
That's 22, the matter is pending.
Any date, my lords, convenient.
Any day on a Wednesday or a Thursday.
Post the matter on non-Muslim day. The SLP number so and so be also tagged.
Great.
Yes, Mr. Chaudhary.
Please, I appear for state. The respondent doesn't seem to be here. There are two petitions before your lordship. I appear in the first one. This, in fact, I think this needs to be sent to the mediation so that it can get settled. This is an ongoing dispute from last several years. 1985, where this was an Inam land. The original Inamdar belongs to me in the year 1985.
Number one is a tenant.
Yes.
Or a
Kabi is a Kadim, my lord. It has to be Kabi is a Kadim or a tenant. He is none. He is given a contract by the government for a year-to-year basis. He is not a tenant, not from the Inamdar. Tenant is someone who is a tenant from the Inamdar. Here, he is someone who got this land to cultivate from the government. I'll show those provisions also. He is not a Kadim or a tenant. Now, what happens is this one. Now, 1985, he executes a sale deed, the Inamdar in my favor. For 23 years, 29 years, nothing happened. you know, an inquiry is initiated by the collector in the year 1993. Now, after 23 years of sale to me, and there he holds that since he was a tenant on the date when the cutoff date, that is not 1st of July 1960, he has a right to be declared as owner or occupant. That's what the authority says. Now, before the collector, connector initially rejects it, but in the review it allows. He says that he was cultivating
You
as a.
You are not purchasing from Inamdar.
I have
You had
purchased from
purchased
Inamdar.
only from a subsequent purchaser.
Yes.
In 1988,
Inamdar sold it to.
You purchased in 1988.
Yes.
The suo motu proceedings are initiated against you within 5 years in
1993.
Within 5 years, not a very long period.
No. What happens? Not from there, Milo. 1960 is the cutoff date. 1st of July 1960 is the cutoff date. From there, 1993 becomes 23 years. So, my lord, he should have initiated from 1st of July 1960 within 3 years. Now the initiation is in 1993. So many hands have, the property has been passed from so many hands. Now what happens is this. If your lordship sees, please have a look at this definition first.
Is there any cut-off date in the statute to determine the status of a tenant who can acquire occupancy rights?
Yes, there is, if your lordship sees, kindly have a look at page 37, the definition. Who can be given, my lord, this occupancy rights?
Yes.
Page 37, if your lordship sees. Section 5. This is Inam Abolition Act and Section 5 at page 37. May I read, Miller?
Yes.
Yes. Occupancy rights in respect of lands comprise.
Mr. Chaudhary, we are not asking you to read such a. One is that we sometimes, mostly I have seen, very poorly drafted statutes in state. Why such a lengthy? We point out cut-off date. What is the cut-off date?
Cut-off date is, my lord, 1st of July 1960. So he has to be Kabizi Kadim or a permanent tenant or a tenant holding from the Inamdar. My lord, that's what section 5.
Where is cut-off date mentioned?
Where is that section? Where is the section? Well, that is issued on the basis of a notification. Notification, I'm not having it right now.
So as only two things, nothing more is required. That what is the cut-off date for the purpose of determining the status as an occupancy as a tenant who can eventually, by virtue of the protection granted under this act, can acquire a better right as occupancy tenant.
Very well. I'll produce that. I don't have it right.
And what does the revenue record says on that day? We need to see the entry in the revenue record on that cut-off date. So, for example, if the date is 1st January 1950.
Very well. I'll produce that.
To see the revenue record of 1958, 1959, and 60 and 61.
Because if your lordship sees the record, which the collector observes, even the commissioner who decides against me says that he was for 1 year as a Lavnidar from the government, who could cultivate on behalf of the government for 1 year.
Which year?
1958-59. But the provision requires that he should be a tenant from the Inamdar or a Kabizi Kadim. Kabizi Kadim is someone who is cultivating it for more than 12 years. That's the definition. Now, he was not a tenant. He had the government. Because this was an Inam land. 1955, Inam Abolition Act came, 54. Now, my lord, he was a Lavnidar or a cultivator on behalf of the government for one particular year. That has not been looked into by the authorities and holds it against us. I'll produce that.
Occupancy tenancy.
I appear for the government. The respondent number.
For the government, private respondent not.
Oh, you are not appearing?
No. They have filed a counter, but my lord, today they are not appearing. Appears.
21st of December 1993. That mentions the
21st of December
1993. 21st December 1993. That is the first order which decides.
See this one. See this order, page 54.
Well, that date,
Sir, page 54. Page 57, 54.
well,
Cloud.
my title is not.
Namdar had no right to sell it.
Please have a look at page 54. Your Lordship wanted to have the date. Well, it says 1/7/1960, but it goes on a footing. It says that whosoever is in lawful possession as on 1st July 1960. That's not the requirement of law. It's not lawful possession. He has to be either Kabiz Kadim or a tenant. Lawful possession is
the transfer to Sopan, that is your vendor or your predecessor, is in 85.
Yes.
When the Inam already has vested with the state. So at that time, the Inamdar did not have any right to dispose by way of sale or otherwise.
What happens is this.
There, your right for recording your name is under cloud.
Well, I'll tell your Lordship how the provision reads. Well, either whoso is occupying the land on 1/7/1960 be the Inamdar or a tenant on his behalf. Well, he becomes owner or by paying some nominal fees. Now, so far as the collector is concerned, it holds in my favor. Since he becomes the owner, the Inamdar. Well, I am the poor person. I have purchased it by paying consideration. He sleeps over his right for 23 years. Would your Lordship consider, I'll produce all those documents?
See, a person who is unable to defend himself here, what? Next.
Very well.
Removal on a water body. Recommendation was made for removal of encroachment on the water body. Direction has been given that.
My Lord, 19, I'm appearing for respondent number 3 in this matter. My Lord, the office report indicate that the appellant has not filed process fee for issuance of notice to government respondent 1/2/12, despite giving an opportunity on the last date.
So as per the office report, notice to so respondent could not be issued as the process fee were not deposited. The petitioner directed to do the needful within 1 week, whereupon land notice will issue to the answer respondents for so date.
Obligement.
My Lord's, with my Lord's gracious
I
intervention.
appear for the
matter has
petition
been
in item
settled.
20. My Lord, the
And,
matter has been
an IA
settled.
Yes, the matter has been settled. my Lord.
They have preferred an IA number 254630, wherein they have annexed the further agreement dated 16th of September, where they have discharged the burden of under the which they have taken.
There was an encumbrance also, my lords, and we have also removed that encumbrance also.
Yes,
We have,
my lords, that has been removed.
Both of you also made a lot of efforts, and because of that, the matter has been settled. Now, you want us to pass a reasoned order or what?
My lords may dispose of the suit.
The appeal may be disposed of. The appeal may be disposed of. Only, my lords, the direction may be given that we may pursue, we may present ourselves before the High Court to withdraw the rental amount that has been deposited. We
Yes,
have
my
agreed
lords,
upon that.
I do not oppose to that, my lords. My only humble prayer is to dispose of the suit in terms of the consent, because the other judgment, the execution will have to be withdrawn by my learned friend.
Yes.
Say, leave granted. Then say with the initiative taken by learned counsel for the parties, the initiative and repeated efforts made by the learned counsels, the parties have entered into a settlement. The initiative and with the efforts made by the learned mediator, the parties have settled their dispute. settle the dispute but there is no formal settlement.
It's recorded, my lord. Along with the affidavit of compliance, we have included the settlement agreement as well.
Yes, madam. 7th of July, 2025.
Settlement agreement dated 7/7/2025, right?
Yes, my lord. July 2025.
In terms of the said settlement, paragraph 10. The settlement reads as follows. Settlement हो गया. Settlement हो गया. One refer to withdraws one. The petitioners will facilitate the withdrawal of sum of 18,60,000 along with interest accrued thereupon in favor of the respondents. The said amount is lying deposited with the High Court. The Registry of the High Court is accordingly directed to release that amount in favor of the respondents. What do you want? You are saying?
My lords may dispose of the suit, like title suit 50 of 2012 in terms of the consent by setting aside all the orders.
It will be disposed of, my lords, in terms of the settlement agreement.
Because
because it's all merged with the appeal now. So the appeal can be disposed of in terms of the settlement agreement.
In view of the above development, the incident, the judgment of the High Court and of the courts below are accordingly modified and substituted by way of the settlement agreement dated 7/7/2025. The party shall abide by the terms and conditions thereof. Next paragraph. Any litigation pending between them before the High Court or any other forum shall also stand disposed of accordingly.
Obliged. Deeply obliged.
My lords, please. My lord, this is that my lords have taken suo motu cognizance. That is from the Allahabad High Court order.
That was stayed probably by the High Court. We had stayed that order.
My lords have stayed the particular paras and the operation of the order.
My lord, the matter.
The final order has to be passed in this way, my lords. The sensitive approach to be adopted by the courts concerned when it comes to matters like these. If my lords may kindly see the order of the Allahabad High Court, my lords have that. My lords may pass on my file, my lords, in that case. But I'll just pass on my file that order.
Anyone appearing for the accused also?
So, my lords, in fact, my lords had directed service. It had reached the Kaskan. So I filed a status report. It may not be on my lord's record. So we effected service on 9th of April 25. And now we have again effected service on 6th of December 25. So what has happened is that, in fact, so the High Court, so the original cognizance was the summoning order was under 376 and section 18. The High Court modified that to 354B. So it's a complaint case. So the trial is supposed to go on. They have not been appearing before.
That despite service, they are not appearing.
Yes, because they are in fact not at home. So we are, and because it's a complaint case, it is listed on 1st of January 26 now.
Oh, if they are not home, that means they are absconding. Well, let us go one by one. That means they are absconding.
No.
And if they are not home and they are absconding, that means they are delaying the trial.
Yes, my lords.
So we set aside the High Court order and
My lord, I am appearing for the complainant. My SLP is 21.1.
What we propose is,
please,
subject to and Shobha is here, you are also here. We
you proceed that.
Evading, if they are absconding, the law has a
trial court, my lord. On 6th November, he has been granted regular bail. When he was on interim bail, that has been confirmed on 6th of November, my lord. Only a few days back.
So that means they are aware of everything.
Let it be satisfied. Let the trial court is at the stage of framing of the charges.
I would only be requesting my lord to make some prediction regarding the approach to be adopted. For a moment, kindly see 3 paras of the High Court order. while setting aside, my lord, some orders coming, observation coming from this honorable court. Kindly see for a moment page para 3 about the facts. My lords, don't have the copy, my lord, may I just pass?
But in my SLP, the copy is there. 21.1, I have the High Court orders and 21.1. Para 21 on.
Three are the facts which have been reported in noted by High Court.
Yes, sir.
This part we have seen, the factual part.
So para 3 is the facts and 21, if my lords, can you have this one, the marking, the court master can please pass it. 21 onwards, can you just see the marking with the circle, those para 21 onwards, my lords. This is para 3.
This part,
Onwards of this.
para
21 onwards of this order.
of the impugned order. That's it. We have seen that also.
21, 22, 23, 24, and 26. The specific words which I have just circled. Preparation and the actual act.
Lordship, judgment is Mahinder Singh.
Have you seen, incidentally, one of my judgment?
I have next, my lord.
Beseeching my lords for.
In Mahinder State of Haryana